Okay, I think I know what this is now. I've got my face over the thing. Okay, I think I know what this is now. This was entered on Friday by Judge Lyman. Just to give you the background, because I think that's important, the New York Times filed a motion a month or so ago, more than a month ago, asking for the court to take the decision it had made to dismiss Wayfair's case against the New York Times, the granting with prejudice of the dismissal of the New York Times from that part of the case, and enter a final judgment saying that part of the case is completely over and done with. And at the time, we weren't really sure why. They claimed in the motion it was for appeal purposes. But then I think we found the real reason, which is that the New York Times has filed an anti-SLAPP case against Wayfair in New York State Court. And what they want to do is take a final judgment to the New York State Court and say, look, we won, we're the prevailing party in a case that tried to sue us for publishing something. So we deserve to have our attorney's fees paid under the New York anti-SLAPP statute. Now, whether they can do that and how that works, I do not know. I've never done that before. There's all kinds of complicated concepts wrapped up in there, like res judicata and whatever. But the New York Times wants the Wayfair versus New York Times dismissal with prejudice to be pulled out from the rest of the case and to have Judge Lyman enter a final judgment saying it is the final judgment of this court that Wayfair's claims of defamation against the New York Times and the other claims, I guess, too, those other ones, are dismissed with prejudice, and this part of the case is now over. Now, part of the New York Times argument was because the Wayfair case versus Lively and the Lively case versus Wayfair were consolidated, right? Remember that Wayfair's weren't counterclaims. It was a separate case with a separate case number, and they were consolidated. The argument that the New York Times made is because they are consolidated, no one has the right to appeal until all of the claims in both cases have been resolved. And therefore, we need you to separate this one issue out so that we can go on with it and be done and out of this case. Now, critically and very interestingly, Wayfair did not respond to that motion. They did not file anything in opposition. They had, I think, 7 days. It's been like over a month now. They did not file any motion in opposition to that motion. They didn't come in and affirmatively say, yes, we support the judgment, but they also didn't say no. So they basically just acquiesce, like enter the judgment, whatever. And that's the reason why this particular document is an order to show cause and not an order on the motion. Because he's saying, I'm about to do what the New York Times asked me to do because you haven't told me not to, but let me give you one more chance. Just in case I missed it, this is cool with you, right? That's what an order to show cause is. An order to show cause is, I think I'm going to do this. Speak now or forever hold your peace. So what the judge is saying here is, hey, I'm about to do this. Wayfair, what say you? Now, what's interesting about this to me, and I feel kind of validated, is that he said the New York Times is wrong on this issue of you have to wait for both cases to be resolved before you can appeal. I thought that was wrong at the time because they're consolidated cases, but they're not the same case. And the New York Times had argued, no, because the cases are consolidated, it all travels together. And this order says, no, that's actually not right. That does not mean that things that happened in the consolidated Wayfair case that has now been dismissed have to wait until the Lively case is over. That's wrong. That's not the law. And he tells them that. And that's interesting because if he's right, the time for Wayfair to appeal that decision passed months ago, which I don't think they think happened. But he's not saying that. It's kind of a weird thing, and I'm not really, this is the part I'm not really sure I understand. I think he's sort of saying in a sideways way, like, I think they already could have appealed this. They just didn't because maybe they had the same misunderstanding of the law as the New York Times did. Maybe they were all working on that assumption the judge now says is wrong. But he says, regardless, I don't think that's the case. And so I don't have to grant your motion for entry of a final. I can just do it. I can just do it, and you guys can move it along. And so he says at the end, based on all of this, like, it seems to me that that makes sense and that's fine. So just tell me why I shouldn't just go ahead and do it. And he actually says, I'm going to deny the Times' motion as moot when I do it. Like, I'm not going to affirmatively grant the Times' motion for a judgment, but it seems to me like you guys need a judgment so you understand when the appeals runs, so I'll just do it, which is interesting. And then this last sentence, this is him speaking directly to Wayfarer. In doing so, the party should address whether any pending motions for fees and costs, including those brought under anti-SLAPP statutes, mean the decision in this case is not final. So you cannot enter a judgment and you cannot appeal something until it is final. So he is well aware of what's going on in the New York State court with that anti-SLAPP complaint. And he's saying, if you, Wayfarer, are going to make the argument in the New York State court case that my decision to dismiss your complaint isn't final yet, you need to tell me now. And alternatively, if you have an argument that the issues of your dismissal in my court, in Judge Lyman's court, are not final because now there's a pending case in New York State court, and that prohibits me from entering a judgment, you have to tell me. So I know that this is all very confusing, and I'm really confused about the way that he is process-wise handling the judgment issue, because I still think you can't enter a judgment on something when there were no fact findings, because there is no judgment. But my read of this between the lines is what he's saying is, okay, I'll close out the New York Times part of the case if nobody cares. Like, if Wayfarer's cool with that, I'll just go ahead and do that. But I do know you've got this other thing going on. Does that change the calculus? And so I think it'll be interesting to see how Wayfarer responds to this. Usually with an order to show cause, you wouldn't just ghost him and be silent the way they did with the motion, the original motion. You would file something one paragraph and say, Wayfarer takes no issue with the entrance of this judgment, even though we continue to believe that, legal errors were made in granting the dismissal in the first place, or something like that. So they may do that. One thing this does do is raise further confusion for me about the lawyers who were recently brought on, the people who do a lot of appeals work, because I thought they were brought on to litigate this issue, maybe. This issue of when are things appealable and when are things consolidated, not because that is a really, really nuanced appeals process argument that even I'm having trouble following, but they didn't even file a response to it. So maybe they'll weigh in on this. I don't know. But the reason it looks different is because Wayfarer has not, usually you file a motion, right? One party files a motion, and then the other side says, here's why that motion shouldn't be granted. And then the judge decides, would I go with this side or this side? Wayfarer didn't file anything. And so it looks like maybe silence and not speaking to it is their best strategy. But this is kind of telling them, this is your last chance. If you don't do anything, I'm going to enter this thing, and then we'll see where it goes. So this could blow up into a whole bunch of legal argument about whether that anti-SLAPP case can go on and when appeals are and all that. It could be a whole big mess. Or Wayfarer could just be like, no, go ahead. I don't know. We'll see.